What the f do you call this? That's me in court, right? In jail. See, this is what, here's the garbage of what you're trying to tell me right now.
What on earth are we even watching here? Picture this. A man in full jail position in court, looking like he's starring in his own personal reality show, and somehow he thinks he's the one running the courtroom. This is peak sovereign citizen energy, mocking the court, acting like the judge owes him a favor, and completely ignoring the very concept of law. Honestly, I feel bad for his attorney because trying to navigate this guy's delusions is probably a full-time job in itself. The guy is facing a trespassing charge, has been skipping court dates, and yet he's sitting here like he's untouchable. As the hearing starts, chaos unfolds immediately. He questions why he even has an attorney, refuses to cooperate, and argues over procedural technicalities that sound like they were picked up from a 5-minute YouTube legal tutorial. He's talking about 1077s and withdrawals as if dropping legal jargon can...
No. Parcel? No. Mr. Christopher. Christopher.
Understood. Mr. Husky, I'm sorry, Mr. Christopher,
Why would I do that?
I should get your contact information.
I'm not interested in being in contact with you.
Oh, okay. Well,
Nor do you represent me. I'm gonna make that very clear right now.
understood. Just to,
And then don't speak when the case is called.
I'll leave that to you. As far as the county is concerned, I've been appointed to represent you.
For what?
In the criminal trespass and obstruction charge.
Oh, because that's the first time that's ever been mentioned in open court
Okay.
with me present.
Okay, that should have been made. You should have been made aware. Well, I guess.
Yeah, there should have been like an arraignment.
Well, and that's pending. There's another procedure that's been started that we need to get through first. If you want to step out, we can talk about it.
No, thank you.
We don't have to. So that's kind of where we're at today.
Yeah, I know where we're at today. I've
Understood.
been doing this almost 500 days, man.
Understood. I guess part of the reason I like to contact you is because you get through this next phase.
It's not gonna happen. That's the whole point of this. That's why it's taken so long. You guys did it 1077 without me present, without me even being heard.
Sure.
Okay, that's ridiculous.
It's a procedure that doesn't require your presence.
It's okay, I'll be back with it.
Now, whether you agree with it or not, I understand, but that's the situation. And that situation in order to-
Here's a little reminder of like what a court can do and cannot do.
Well, according to Washington state law currently, the court's able to do this without.
Oh, really?
And in order to get past this step, I need to be able to coordinate with the people that are gonna talk to you and yourself so that we can get that set up to do it. If you want to move on, then we have to get through that step. I understand that you maybe don't want to or agree with it.
See, this is what, here's the garbage of what you're trying to tell me right now. Literally 1 year, 3 weeks, and 1 day ago, when I was in courtroom 3 with Samuel Meyer, he's the one who actually gave anything substantive in this case to me, as far as information is concerned.
Well, if
And
you
what
want to talk
he
to it,
said,
how are we supposed to
hold
do that?
on. What he said was at any time, the 1077 can be withdrawn.
Well, I can't withdraw it if you won't talk to me.
I've talked to everybody. Why would I continue talking to you guys? You guys are going to be a future defendant.
and somehow override reality. Meanwhile, you can literally see the attorney questioning every life decision that led them to this point, probably mentally rehearsing their I quit speech right in front of the judge. And the energy is just wild. He refuses to communicate, claims every lawyer who's ever represented him is secretly working against him, and insists he's capturing all the court hearings on YouTube because apparently no one told him they were being streamed. Classic sovereign citizen move, thinking the system is conspiring against them, blaming the world, and never, ever taking responsibility. The courtroom is basically a live-action experiment in human delusion. You can see the Meltdown building with every word, and it's painfully clear that no matter what happens, This guy is about to collide.
I've made that really clear. Samuel Meyer has everything that he needs from me. And here's the biggest problem. Tell me what the 1077 is about. Is it about allegedly I didn't want to go to court or I didn't want to talk to anybody? What the do you call this? That's me in court, right? In jail.
Well, I understand your position on that. Just like being new to the case, I'm not privy to that.
Well, now you're hearing it.
So I've basically got two options here. I mean, either I can give you the, well, I could give, if you'll provide me with your contact information, I can give that to
You guys already have it? Nobody's giving me a letter. Nobody's giving nothing.
Okay, if I've seen like situations where you've refused to receive the mail.
Who said that I refused to receive mail?
That's just my-
Mr. White, I just want to remind you that this is not confidential. Everybody can hear this. I just want to remind you. Okay.
And that's, I asked him if he wanted to step out and talk and at any rate, if nothing else, I can facilitate communication between you and the people that are supposed to do that. But I don't have to necessarily do anything else, but we have to get past that phase in order to move forward on your case.
I want it withdrawn and I want to proceed on my own without an attorney.
Okay, well then you and I will have to talk because I'm the one who has. to
So
request
let's see here. Let's name all the alleged attorneys that have been part of this case that I have spoken to personally. We got Stillwell, we got Kale, we got Lesh.
Okay, and again, I'm not privy to that. I don't have any of that information.
Mhm.
And if you want me to request to withdraw that, then I need to talk to you about it. And if you don't want to talk to me, then I don't really have a choice.
I'm sorry to interrupt. I'm just gonna ask that volume and behavior is acceptable at what court has going on. And
Okay.
At some time, if you become disruptive, we're gonna have to ask you to leave. So
I get it.
I'd like you to be as efficient as you can. and
I
as
get
much
it.
done as
Trust me, I
possible.
don't want you dragging me away when I
No,
got
nobody
cane
drag
mask.
you away,
It's gonna hurt. It's gonna
Once the
hurt.
judge is in here, he might ask.
No,
you
no,
to
no. Me and Paul, we know each other.
Okay.
I've been doing this a really long time with him. That's,
Alright.
you know,
I'm just checking in on. just letting
okay.
you
No,
know.
I appreciate you, man. I appreciate it.
I appreciate your appropriate behavior as well.
Okay. Absolutely, I appreciate you. Thank you so much.
So basically, she said, if you want me to request to withdraw the request, then I have to really talk to them. Find out what purpose of the request was submitted for, and then make a decision based on that. Now, when you represent yourself, it's not necessarily grounds for that request, but you gotta have a request.
Neither do I. I just hear alleged.
And that's what I'm saying, like, unless we talk, I don't have the information I need to move forward.
For the record, Isaac, me, him. That's a hearing.
No,
Okay,
I understand.
but it's not on the record. It happened November 13th. It's not on the record.
Have you submitted any public records requests for the audio of the hearings?
I already have them, man.
Oh, you do?
Yeah. The funny part is nobody told me once that these things were live streamed on YouTube. I already knew that. I've captured all of them.
Well,
Every single hearing I've captured from YouTube.
so that's one of the things that we should probably talk about outside of court. So again, offering to step out and speak with you if you want. Or even just step back into the back corner and speak, but we'll lower the volume sound.
I'm good.
Okay.
Okay. Everything that you want to have a conversation with me about can be right here.
Well, I mean, part of my role is to inform you as to your rights and help you protect them, so.
Well,
With the law in a spectacular train wreck of epic proportions, he demands to proceed without an attorney, wants certain filings withdrawn, and argues over hearing dates while tossing around legal terms he clearly doesn't understand. The judge tries to maintain control, explains the process, and reminds him about competency evaluations. But the guy just keeps digging himself deeper. You can almost feel the courtroom collectively holding its breath, waiting for the moment when the inevitable crash happens. This isn't just a court session, it's a slow-motion meltdown, and trust me, you do not want to miss the fallout. Now, let's pick up where things really start to spiral. The guy is adamant that every attorney who's tried to help him is secretly working against him. He's convinced there's some grand legal conspiracy targeting him personally, because apparently he's too important for the rules to apply. He argues, he interrupts, he lectures, and he refuses to cooperate, all while tossing out terms like 1077 and withdrawal, as though saying,
What was that date when you said?
Hmm?
The date of the hearing, you said wasn't.
The one that happened in custody was November 13th, 2023.
Oh, it's written down in the record. I don't know.
Really? They changed it, huh?
You said it was November.
13th, not 30th. 30th did happen. I was there for that. That was the first out of custody hearing that I had.
Well, if you want, we can talk about that more. But if you don't, that's fine too.
I think what we can settle on is asking for a separate hearing.
And that's fine. We'll do
Okay.
that.
But just remember, this isn't a matter of you representing me. This is a matter of me trying to cooperate in terms of
Well-
work with the court and everybody to get this resolved.
Well, and
I guarantee nobody else really wants to continue seeing me. And it doesn't matter what happens at or after a trial.
So
We can get this done.
So here's the thing. Again, as far as the county is concerned, I've been appointed to represent you.
That's,
So if I say it that way, I'm not necessarily saying that you're accepting the
I
representation.
understand that.
That's just me trying to clarify the record
Yeah,
as to what my role is at this point.
yeah, I get that.
And then if at some point you want to represent yourself and the court finds that you're able to do so, then they'll allow you to do that. If you want standby counsel, you can have an attorney appointed
Mhm.
to assist you with interpreting the law
Mhm.
and maybe preparing your case.
Mhm.
You don't necessarily have to work with that attorney, but that attorney is basically provided to answer any legal questions that you might have. And you probably have plenty of information on that at this point as well. So we'll just ask for that hearing and move forward from there.
Please. Okay, Mr. White.
I guess we'll start here with Mr. Christopher. As he's listed on the docket as Mr. Christopher Hartzell.
Mhm.
I have been appointed by the county to represent Mr. Christopher, although he has expressed that he does not want representation. He has a pending 1077. He's been advised by the court that that can be requested to be withdrawn at any time. And he would like to request to do that. However, that might take a little more time than we have on today's docket. So we're asking just to set a hearing where he can address that. And that's my case and Mr. Holcomb's case and Mr. Christopher's case to address. I suspect, how much time do you think you'll need, Mr. Christopher? Half an hour? Less?
For a hearing?
Yeah.
Oh, I'm sure a half hour would be fine.
So if the court has a half an hour that we could set that for, I suppose at the court's convenience, obviously as soon as possible.
Well, okay, we still don't have the competency assessment
We
yet.
don't, Your Honor, and that's kind of the situation.
Right,
is that, if Mr. Christopher doesn't want to communicate with me or the hospital, and he wants to represent himself.
Yeah, we
we're kind of
had
in a bit of
this,
an impasse.
we had this discussion already and a ruling on it. And the ruling was that we're not going to make any determination about self-representation until after competency is determined. We had the whole discussion previously and nothing's changed. We're not going to revisit that.
I still object to it.
That's fine. You don't have to keep saying it either. You objected one time and that preserves it forever.
Cool.
So keep in mind that if you said it once, it's been recorded and you don't have to keep saying it.
Excellent.
Could we possibly set a hearing then just to address how to move forward?
We're going to set a hearing to determine competency, which we have, that is a threshold issue that we have to do. A person who's not competent to proceed cannot represent themselves either. So we're going to determine that first, and then after, and I've explained this to Mr. Christopher, after we've determined, assuming that we determine he's able to proceed, then we'll proceed with the potential of self-representation.
Saying them louder somehow makes them real. It's one of those moments where you just have to sit back and admire the sheer audacity of human delusion. The judge tries to lay out the facts calmly. There's a competency evaluation that must happen first. Until the court determines whether he's capable of representing himself, all this shouting, objecting, and grandstanding is essentially meaningless. And yet, he continues to push, demanding to represent himself, questioning every procedural step, and acting like the law is some sort of suggestion rather than a set of rules everyone else has to follow. You can almost see the judge.
But all of those advisements and that have to occur and the understandings that the court has to find in order for a person to be able to represent themselves can't be done until competency has been determined. So I just want everybody to keep that in mind, that will be the procedure, and we're not going to revisit that over and over again. So we've got to get to the point of the competency determination first.
I have one question for the court. What exactly is the 1077 over?
Couple of months. Yeah. I'm sorry, what was that question?
What exactly is the 1077 order about? Why was the order, sent off to Western State Hospital?
Well, generally what it's about
Mm-hmm.
is it's an order from the court
Mm-hmm.
to conduct an examination, in this case of you,
Mm-hmm.
to determine whether you are able to proceed in this case.
So why?
Because there's been serious doubt raised by the attorneys interacting with you that you may not be able to do that. And it would be a violation of your rights to proceed with a criminal case against you if you were not competent to proceed with the case.
And what is being alleged
About the crime that's alleged?
Sure, yeah, we'll
Or-
start with that.
Well, the crimes that are alleged are trespass in the first degree and obstructing a law enforcement officer.
Okay, that's the first time that's been said in open court, other than Samuel Myers saying trespass. I heard Samuel Myers say trespass, so obstruction.
That's still one of the charges.
Okay.
Yeah.
But what is it exactly that they're having doubts about competency? Like what are they alleging? Because what I heard from Samuel Meyer is that somebody has alleged that I didn't want to talk to anybody and that I didn't want to come to court.
Well, that may have figured into it. I don't
What do you call this? I went to court.
I'm glad you did. Yeah, I know you were here previously because we've talked about this. Okay, so what we're gonna do is.
Yeah, we talked about this while I was in custody.
We're gonna get that evaluation completed, and we'll reconvene on that issue on May 16th at 9 o'clock.
So I don't know if any changes, feel free to give me a call, because I don't have to advise you, but we can have a conversation.
Excellent. Thank you so much.
All right, you're good to go, Mr. Christopher.
Eyeing through the screen, thinking, here we go again. Meanwhile, the attorney is in full damage control mode, trying to explain how representation works, how the hearings function, and why he can't just skip the competency assessment. But the sovereign citizen has already checked out of reality, claiming he's fully prepared to fight the system alone. It's like watching someone try to build a spaceship out of cardboard. They have the confidence, they have the energy, but the foundation? Not even close. He insists he has captured every hearing on YouTube, refuses to take letters or communications from the court seriously, and keeps revisiting old hearings as if repeating the past will somehow rewrite it. The courtroom becomes a surreal mix of procedural explanation, delusional tangents, and sarcastic undertones. You can feel the tension crackling, every word, every interruption. Every ridiculous claim is pushing this case closer to a full-blown meltdown. And here's the kicker. This guy genuinely believes he can outsmart the system by representing himself. Half the time, he's just throwing around random legal jargon he barely understands, hoping the court will fold under sheer audacity. But in reality, if he ever actually represents himself, it's going to be absolute chaos. The judge has no obligation to help him, and all those warnings, explanations, and procedural safeguards, they're just building blocks for the inevitable crash. Watching a sovereign citizen try to navigate real law is like watching someone fight a lion with a toothpick. It's painful, absurd, and somehow mesmerizing all at once. By the end of the session, the court sets a date for the competency evaluation, and it's clear that the clock is ticking on his delusion. You can feel the suspense. The audience is left waiting, wondering just how spectacular this train wreck will get. One thing's for sure, no one in that courtroom is under any illusion that this guy is about to walk out with a victory. He's fully committed to the meltdown, and the only question left is how loudly it will explode.